Okay, welcome everyone. We got some more people coming here. Okay, welcome everyone. My name is John O'Brien from the Keystone Contractors Association. And today we're talking a little COVID-19 and workers' comp. We've seen an uptick in the number of cases the past couple of weeks. Different mandates and different executive orders are coming out of the governor's office. So that leads to a lot of questions, a lot of uncertainty, a lot of confusion. And we're just glad today to have some experts with us today on a panel that are going to help try and clarify some confusion related to workers' comp. I'm excited to feature our panel today representing two great firms, Babst, Calland, and McConkey Insurance. From Babst, Calland, we have John McCreary, and Dave White. Dave will be jumping in if needed, but John will be running the show for Babst, Calland. And then from McConkey, we have Ed Tobin and Tim Ziegler. I think I saw Tim. Yeah, there's Tim. And same with this firm, Ed will be kind of leading the show and fielding the questions, and Tim will be there if needed. If questions he wants to jump in, that's fine too. So, but this will be the Ed and John show. So
completely unrehearsed, I might add. So.
Yeah.
He's joking, of course. We've been up since 5, practicing our lines, But yeah, welcome everyone. So I thought a good way to kick this off to start would be just to kind of hear from Ed and John, just to kind of provide some opening remarks. So we flipped the coin ahead of time, and Ed won. So Ed, you're up first.
All righty then. Good morning, everyone. Thanks for having me here to present in front of you. And it's like John had said, I have presented before on COVID with respect to KCA, but just a bit of a background in case I'm new to you or we haven't had the opportunity to link up before. My name is Ed Tobin. I work with McConkey Insurance and Benefits, which is a captive insurance provider as well as market insurance provider based out of York, Pennsylvania. My role specifically within the company is Director of Claims. So I help large contractors, construction, manufacturing, other types of employers throughout the state with their insurance exposure, specifically on general liability, auto liability, and workers' compensation lines, both in the captive market as well as the public market. Prior to joining McConkey Insurance, I worked as a workers' compensation defense attorney throughout the state of Pennsylvania. So I represented third-party administrators, adjusters, and insured such as yourselves throughout workers' comp in Philadelphia all the way out to Pittsburgh. So that's really been my background coming into this. I know John, previously as we discussed, COVID-19 in a workers' compensation era, part of the issue that always comes up when you have a new phenomenon crushing up against the law is the law, and how it reacts to that tends to lag behind. That hasn't changed at all here with respect to workers' comp. But what I'm hoping today is to take some of your questions and to give you guidance on how these factual scenarios may play out, or what specifically you need to look for to set yourself up in the best possible position when and if you're faced with a COVID-19 either outbreak or one-off claim with respect to your own employees. I will tell you at this point specifically, Pennsylvania courts have not definitively weighed in on whether or not a COVID-19 claim is in fact compensable as a work-related claim. In my previous presentation, I laid out sort of the legal history that I think supports that if push were to come to shove and this were to be litigated through the administrative Commonwealth Court up to the PA Supreme Court, eventually there is a framework under which you could find a workers' compensation claim is relatable and is compensable if it's a COVID type of claim. That being said, at this point, we don't have definitive case law on that. Working forward from there, I think really the question that a lot of employers have is, what's the best way for me to handle a COVID-19 alleged claim? And I think as we go through this and we answer some of the questions that you guys have, we may be able to add and bring on some more clarity for that. But I'll turn it over to John. I know John has more of an employment law, broader employment law background on this. So John, if you want to introduce yourself and sort of let the world know how you see COVID-19 in your eyes playing out under Pennsylvania law.
Thanks, Ed. Yeah, my name is John McCreary. I'm a shareholder at Babst Calland in the Employment and Labor Group. I work with Dave White, my colleague over there, on our construction clients, or with our construction clients. I'll piggyback on something that Ed said right before he concluded his remarks, which is the uncertainty in Pennsylvania about the compensability of COVID-19 workers' compensation issues. I will note that yesterday, having gone on to the Bureau's website, I discovered the information for Pennsylvania employees impacted by COVID-19. It's a PDF document that looks a little bit like that. Now is when I should be sharing my screen.
Yeah.
But it does state on this information sheet that employees have two filing options. If you believe you've been exposed in your workplace, you may be eligible for comp by notifying the employer to file a disease as injury claim, which maybe Ed can give us some more insight into that. It requires you to provide medical evidence that you've been exposed to COVID-19 in the workplace. Or the other type of claim would be an occupational disease claim, which requires the showing of that COVID-19 occurred in more in your occupation or industry than in the general population. So as Ed suggested, the mechanism for employees to file claims for COVID-19 related illnesses already exists. I will also note that given my sort of broader employment background, that there are, all of you are probably aware of the CARES Act and the Family First Coronavirus Act, which provided for paid sick leave for a limited period of time for people affected by COVID-19, employees affected, and also expanded FMLA coverage for employees affected by FMLA or by COVID-19. Those two benefits, I guess you'd call them, mandated benefits, they both expire at the end of the year, absent some extension, but those have to be integrated with your workers' compensation concerns as well. And then finally, there's the Osha aspect of this. Osha has published a directive to its inspectors in March, I believe it was. No, I'm sorry, it's May, providing guidance to the inspectors as to how recordables are supposed to be, recordable injuries are supposed to be recorded in the event of COVID-19 exposure or illness in a workplace. It is required that you record those, and you have to undertake a reasonable investigation into the origin of that ailment and then record it if you cannot conclude that it was not, the exposure did not occur at work. So there's that aspect of it, which many people are probably going to overlook as they address this situation.
Thanks, guys. And Dave and Tim, if either of you have comments you'd like to share, feel free to jump in. But we'll get to the meat of the program here and answer some questions. If you have questions, feel free to unmute yourself. You can either bottom left hit the mute button, or you can hold the space bar down to ask a question, or you could type it in the group chat. Please don't email it to me. I'm not checking my emails, so we've had that happen in the past on these sessions. But yeah, I've received a few questions, and we'll start there, and then we'll field some questions from the audience. So first one here. I'm a union contractor that has a few workers at home after they tested positive. I'm paying their wages. Am I also required to pay their benefits while they're at home?
The answer to that is yes. If they are being quarantined as a result of a government edict, local or state, or because they are ill, they have actually been exposed, or they meet the other criteria for eligibility under either this paid sick leave or the Emergency Family Medical Leave Act, the employer is required to pay their medical benefits, even as a union contractor. There is a specific provision of the emergency regulations that were promulgated in connection with the Family First Coronavirus Act, and that for multi-employer plans, which is what I assume this question is related to, the regulations in the act require that the making of contributions to a multi-employer fund or other program consistent with its bargaining obligations in the collective bargaining agreement. Contribution must be based on the amount of paid sick leave and expanded family medical leave to which the employee is entitled under the applicable provisions of the Act, based on each employee's work under the multi-employer collective bargaining agreement. I had a client ask this question of me day before yesterday, and it turned out that the employees affected had enough banked time to maintain their coverage while they were off. And I interpreted this regulation to say that no contributions were required under that circumstance. And a caveat to the client being, I'm not sure I'm right about that, but since they won't lose coverage, you are complying with the law by having them their coverage being maintained. A query to anyone out there, or if that in fact was not the case, if my banked time was not sufficient to cover my leave under one or both of these laws, I think contributions would have to be made under that circumstance.
Ed, do you have any comments? Or?
No, obviously that's more toward John's area of expertise in the CARES Act and how that intertwines. I'll echo the sentiment. I believe the benefits are payable under that 14-day period as it's outlined both federally and by the state.
We have a comment here from Penny Orr. Penny said, we were told this morning by the Carpenters Union and Laborers Union that the 10-day COVID pay would not be subject to benefits. So maybe each trade is different. So,
well, I guess a lot of it depends on the collective bargaining agreement, as the regulation recognizes. So if you're paying weekly, it may be required. If you're paying monthly, it may not be. So I think the key here is for anybody who's confronted with this issue is to find out whether your employees are going to maintain their coverage during the period of their absence. If they are, because you prepaid or whatever it is, then you're probably okay. If not, then I think you have to take measures to ensure that they do maintain their coverage during that period.
Mm-hmm. Thanks for that comment, Penny. And Penny broke the ice so others can follow and type their questions. The chat room is working, people. Okay, here. Question number 2 here. We are entering a slow period and we expect to start to lay off workers. We're hearing that some of our workers plan to say they tested positive for COVID so they can receive workers' comp. Do I have to pay them?
So I'll answer this in the way the question leans a little bit. The answer to that is no for the upfront, unless they can demonstrate a compensable claim. So as John sort of outlined toward the middle of his remarks, there's 2 ways in Pennsylvania to outline a compensable workers' compensation claim. One is an injury that occurred during the course and scope of your employment. The other that John outlined is what we call the Occupational Disease Act. Now, for most of the people in this room, the Occupational Disease Act really isn't going to take place. What that act is really for, the best analogy I can give people is individuals who used to work in the coal mine and develop black lung. That would be more cognizable with an occupational disease. That is, by virtue of my employment and by virtue of the type of job that I performed, I was more likely to contract this type of illness or disease. Thus, the onus is then put on the employer to demonstrate, no, you developed cancer of the lung through an outside source. It sort of flips the burden. I think that's something that could come up in a coronavirus setting as it relates to the medical field, but not so much as it relates to contractors or construction workers such as yourselves. With that being said, then the only way that an employee is going to be able to receive benefits for COVID under a workers' compensation claim in this industry is 1, to demonstrate that they developed the illness during the quote course and scope of their employment. 2, that they suffered some kind of harm That is that they suffered a loss of wages or incurred medical bills as a result of that. And three, lastly, that there's a causal connection. That is, the virus itself is connected to the employment, which is connected to the loss in income or the medical expenses that they incurred. So with that backdrop, if an individual alleges that he suffered COVID on the job, he's going to have more than just that allegation. There's going to have to be a factual pattern which adds up, showing the causal connection or the point of contact for COVID being at work other than outside of work. That's one of the reasons that COVID-19 specifically presents such a unique issue for the courts to consider. Essentially, it's like asking the court to consider whether or not the seasonal flu is work-related. Typically, you don't see a case like that brought in the workers' compensation system simply because from an exposure standpoint, it's not that great. The employee stays out of work for a couple of days. He's paid sick time for maybe 1 or 2 days. Under the Workers' Compensation Act, you don't have to start paying for a recognized injury until 7 days have accumulated. So it has the ability to carry as a virus like the seasonal flu, yet has more of a lasting impact when you get into employees who are risk averse in this setting. So what I would say is, no, they can't just allege workers' comp that it's COVID related, show a positive COVID test, and then receive ongoing wage loss benefits. However, to the extent that they are able to show that COVID was contracted at the work environment, that they suffered ongoing wage loss or medical benefits, and that there's a causal connection between the two, under that specific scenario, yes, they would be entitled to workers' compensation benefits.
And I will chime in here with the scenario potentially makes the employee eligible to claim emergency paid sick leave under the Act, assuming that he or she has not exhausted the 80 hours, which is available under the statute. The caveat there would be that benefit would end if they were in fact laid off for lack of work. It only is intended to compensate for the 80 hours of work lost due to COVID-19 issues, the inability to work due to COVID-19 issues. So if the season is slowing down and the jobs are winding up, and that's the reason for the layoff, then the sick pay entitlement would end at that same time.
Okay. Looks like we got a few questions here. We'll start with Andrea here. If an employee tests positive and contracts the virus outside of work, what steps are we to take? I'm just not sure if we are to pay their wages, file for FMLA, or anything else.
If the employee tests positive, the two newly enacted or recently enacted federal statutes come into play. The Emergency Family and Medical Leave Expansion Act, which now applies to all employers under 500, as opposed to the regular FMLA, which applies only to employers over 50. So Walmarts of the world are not covered by this, but many contractors would find themselves covered by this statute now, where they may not have been covered by the FMLA before. The excuse me, the eligibility requirements for the emergency FMLA, if I can find them here, I'll get all of them for you. I had them up on the screen. The employee has to be unable to work or telework due to the need for leave to care for a son or daughter under the age of 18 if school or childcare is not able to be provided. That the employee has him or herself been diagnosed with the disease, whether the experiencing symptoms, caring for an individual who is subject to a local quarantine order, and there's 6 or so qualifying circumstances. So under the scenario in the question, the emergency FMLA leave would likely be available. And there's also the emergency paid sick leave portion of it, which provides 80 hours of the regular rate of pay, subject to a cap, for individuals with the same sort of eligibility criteria. Under the FMLA, the first 2 weeks of leave under the emergency FMLA leave are unpaid, but the 2 weeks or the 80 hours of paid sick leave could be used to pay that FMLA leave. And then subsequent weeks of emergency FMLA leave are paid at 2/3. It's the only form of paid FMLA leave that exists. And as I said earlier, both of those statutes are scheduled to expire at the end of the year, although I would not be surprised in the least if they were extended into next year.
Okay. Andrew, if you need a follow-up, hopefully that answered your question, but if you need a follow-up, feel free to jump in. Otherwise, we'll move right along here. I see Mike Penrod chimed in here. Mike has a question here. If employees living outside of the same household have been instructed they may not ride to work together and choose to ignore that rule, would that be grounds to deny a workers' comp claim should they both contract COVID?
So Mike, I would say, yes, you have the argument there. And this goes back to, in the presentation I gave previously, we sort of outlined 3 employees coming to a construction job site and the factual scenario and how they cross-contaminated each other affects the outcome of whether or not that's compensable. In Pennsylvania, they have what's called a coming and going exception. And that is that if I'm coming to work or going from work and I sustain an injury, that's not compensable as a quote unquote work-related injury. Now that rule was put in place, obviously not with COVID in mind. That rule was put in place to make sure that insureds were not responsible for everyday motor vehicle accidents and those becoming compensable. However, I think when you take that rule and you string it out and you put it in this context, you have a reason or defense rather to rely on to deny that workers' compensation claim. That being said, and I think John can certainly echo this, lawyers are there to argue certain points. So if this particular employee rides with him there and he says factually that he sat in the back or that he had a mask on the entire time while they drove in together, and say there's a separate employee who he came in contact with on the job site who also had COVID-19, there's another avenue for which a judge could say, well, he didn't contract it during that coming and going period. He contracted it while on the campus or on the location. So your factual scenario clipped as it is, Mike, I would say, yes, there's a reason there to deny the claim and a defense to the workers' compensation claim. But in looking at it not within a vacuum, I would say it's more of a defense that you can offer if in fact a claim petition was filed, and rather than a reason to deny on its whole and 100% you'll win because of that reason.
The scenario or the question also brings to mind the employee misconduct defense available in Osha matters, which to the extent that this became some sort of citable offense under Osha, you could raise the issue of violation of the rule as a defense to that claim as well. But for the other benefits available under the paid sick leave and the Family Medical Leave Act, it would not be a defense to payment under those acts for the fact that they violated a rule or whatever. Those are sort of no fault kinds of benefits that the Congress has provided.
Yeah, thanks, guys. And as part of Ed's response, he mentioned the presentation. That is loaded up on our YouTube page. Ed's a YouTube star. He did a great job. It's very informative, 25, 30-minute presentation. So check it out. Okay, here. Hopefully you're good there, Mike. If not,
And just to clarify one thing that I think maybe goes without saying, but John, when you're talking about the 2 federal laws, we're looking at a limited window of 14 days for payment of wages and benefits, correct? Versus on a comp claim, it would be ongoing.
Correct.
Until you were able to terminate.
Both federal statutes are capped with the paid sick leave. It's capped at an amount. I can't, it's 80 hours is the maximum. And then even that amount is capped at a dollar amount, the number of which escapes me at the moment. And under the FMLA Act, it's 12 weeks is the maximum, less any FMLA that the individual may already have taken for those employers who are already subject or who have been subject to the Family Medical Leave Act before the advent of this plague. So.
Sounds good. Okay, here's Penny Orr here. If an employee is asked to quarantine because of exposure to someone who tested positive at work and collects unemployment until he gets tested himself and then tests negative and comes back to work, what pay should he receive during that waiting time? Dude.
Well, under the Emergency Paid Sick Leave Act, if the employee is quarantined, either because of a state or local quarantine order, or has been advised by a healthcare provider to self-quarantine, which I think is the scenario in the question, he or she is entitled to up to 80 hours of pay at straight time, with the cap, which in most cases would not be exceeded. So the unemployment aspect of it suggests that the individual has been out for more than a week, because you have the waiting week and unemployment compensation. And during that period of time, the individual should have been receiving wages at the regular rate, so should not have been receiving unemployment. So apparently the wages under the Emergency Sick Leave Act were not paid, which presents a problem if the individual was eligible for it, because you can be sued for not following the law. Surprisingly, that's how lawyers make their living. And that's how governments, impose mandates on us. So if the employee tests negative and then is able to return to work, eligibility for the paid sick leave would end. And if that absence exceeded more than 80 hours, there would be no further entitlement as well. The unemployment aspect of it suggests that that statute wasn't followed, or else the employee is committing fraud, one or the other.
Any comments, Ed, here?
Just piggyback on that, I think it's a rare scenario in terms of timeline that the unemployment would be received that quickly. I guess during a COVID era, that's possible. But as John indicated, I don't even think the act allows for an offset for unemployment. So I think the violation there, you would still be held to the same standards of the 2 weeks paid during that period, regardless of the unemployment. And I don't even believe the employer would be able to offset that unemployment if in fact it was able to be calculated and put before a judge. So
that's correct. And also I will say that based on what I'm hearing, the Unemployment Compensation Bureau is extraordinarily backed up with processing claims, because a lot of people have filed claims in the last several months. And it would be virtually impossible for an employee to get unemployment quickly in today's environment. So.
Okay, we have a question here from Mechanicsburg High School alum Paul Martin. Go Wildcats. If a union employee has a sick family member with COVID in their home, and per our company policy requires them to stay home, are we responsible to pay them until they are eligible to return to work, or is it a temporary layoff?
If the employee is caring for a son or daughter whose school is closed, sick son or daughter whose school is closed, it doesn't have to be sick, school just has to be closed, or caring for an individual who's subject to a quarantine or isolation order, or has been advised by the healthcare provider to self-quarantine, i.e. I'm sick with COVID, stay home, stay away. Those four scenarios entitle the employee to the paid sick leave, the emergency paid sick leave. So if you are aware of those conditions, and the employee is entitled to be paid if he or she meets those eligibility requirements for 80 hours. Up to 80 hours, I should say.
Okay. Ed, you good? Okay.
I'm good. John nailed that one. That's kind of why the act was put in place to cover scenarios like that.
Right.
Okay, here's Caitlin. What obligations are there from a liability standpoint associated with someone in the workplace that has someone at home with a pending COVID-19 test? If all paid time off has been exhausted, including prior quarantine of EPSL 80 hours and telework is not available.
If all eligibility for the federally mandated benefits is exhausted, then there is no further obligation to pay. You may have personnel policies in place that would provide a leave of absence to that individual. If FMLA is not yet exhausted, there may be eligibility under either the emergency FMLA or under regular FMLA if you're covered. Remember, there's the distinction. Fewer than 500 are covered by emergency, but you must have more than 50 employees to be covered under the regular FMLA. So that might be available as well. But once an employee has exhausted the mandated benefits, there is no further legal obligation other than, and there may be a policy obligation in any particular company. And it wouldn't even be an obligation. It might be a policy that addresses the situation.
And just to, in terms of when you're an HR personnel or you're looking at claims like this, I had a law professor that used to tell us, look at it like a Plinko board. And whatever the answer is, yes or no on one thing, go to the next question. So, what your factual scenario outlines is, we've used up the 80. Well, where's the next step on the Plinko board? That's going to be looking at your FMLA time off and the emergency FMLA time. If that's also exhausted, you've reached sort of the end of the Plinko board, as John outlined, and there's no longer a duty or an obligation on behalf of the employer to, one, pay benefits, or to, two, keep the job available and open. So when you start way back when, is it a work-related claim? If it's yes, you sort of follow the workers' comp guideline of submitting the claim, getting a denial and litigating that. If it's no, then you bump it over to the CARES Act and then the emergency FMLA. And that's sort of going to be the flow of looking through this. Obviously, with that, let me caveat and say, if you have a question or an issue, contact an esteemed lawyer such as John and have him look at that and weigh in. But before you make that phone call, that's the way I would counsel my clients to think through a situation as it comes up on the fly.
Good stuff. We have Andrea Greenland coming back here with a question here. If an employee is sick and requests to take off work due to going to get a test done, but the test come back negative, do we need to pay wages for that time?
Under that circumstance, I would say yes, if the sickness is symptoms of COVID-19, which is subsection A3 of the Emergency Sick Leave Act, which entitles the employee to be paid sick time if he or she is seeking a medical diagnosis and experiencing the symptoms. So that period of time, I report with whatever the symptoms are, and I say I'm going to go get a COVID test, that 2 or 3 or 5 hours, whatever it is, would be compensable under the Emergency Sick Leave Act. If I say that I am suffering from a stomach ailment and go to the doctor and end up getting a COVID test, no, probably not. So, but that scenario as described in the question would be compensable for the period of time that the employee lost work due to seeking the test.
Okay. I have a question here. Both of you have proven to be experts on the topic. What is the best way to reach you for our audience? So. Cell phone or email? What do you
For
got?
me, it's cell phone or email, and
Okay.
my cell phone number is 412-860-6828. And email is jmccreary, first initial, last name, which should appear on the screen there, at Babst Calland, BABSTCALLAND.com.
And I would be the exact same, email and cell phone. My cell phone number is 717-572-0305. And my email is etobin, T-O-B as in boy, I-N, at McConkey. So that's EKMCCONKEY.com.
Perfect.
Both of our firms don't like easy email addresses, as you guys know.
No.
Yeah. Yeah. And as a follow-up, I'll also send out their information so everyone has it. Any other questions? I did receive a text here from Brenda. Someone's having trouble logging on. This will be posted on YouTube, so I'll send you the link, Brenda, afterwards. So any other questions at all? Oops, looks like we got a.
Mike Penrod has one apparently.
Oh, there's Mike. Okay, so there it is. So theoretically, for a union tradesperson, they're better off taking emergency sick leave since they get wage and benefits versus worker comp, which only pay 66% of their wage of their pay.
Actually, that brings up a question I'm going to ask Ed when after I respond to that one. In theory, for 2 weeks, it's better for the individual to take the sick leave because he gets his full rate and maintains his medical coverage under the statute. Once that 2 weeks is gone, however, if he qualifies for emergency FMLA leave, then he would get 2/3, which is the same as workers' comp, and continued medical benefit coverage. And I guess the question for Ed I would have is, are you aware of how the paid sick leave, for example, or FMLA would integrate, if at all, with workers' comp? Because there's some overlap and duplication there.
There is some overlap and duplication. However, what I'll say there to that is when you're looking at both of the emergency FMLA and the CARES Act, you're looking at a capped benefit at some point. Theoretically, in workers' compensation, you are not looking at a capped benefit. So if I was speaking with an actual employee or a union tradesperson, as you're outlining, what I would say is, while you're getting this test, we're going to file a claim petition if we think it's work related. If we think we can take off those 3 points, which is you contracted COVID, you believe it happened at work, and you have medical bills and ongoing wage loss that's relatable to it. While we file that claim petition, however, your employer is under the obligation to continue to pay you for these 2 weeks. If down the road in the future, it would be deemed that that it is indeed a workers' compensation compensable injury, they would be entitled to an offset for those payments. So hypothetically, if he's out, let's say he exhausts the 80 hours and then he exhausts the 2/3 time. So now we're talking probably 14 weeks out, and there's still ongoing wage loss exposure. In that particular circumstance, from that 14-day week period ongoing, that would entitle them to ongoing workers' compensation benefits. Why, from a workers' compensation side, it's a difficult claim is most of the time the individual is going to be back to work during that period of time. What you're really going to be looking for in terms of exposure on the workers' comp end is the individual who comes with comorbidities that unfortunately passes away. And if that's deemed work related and you have ongoing indemnity benefits for a fatality claim, that's where this becomes costly. Most of these claims hypothetically should take care of themselves within that 2 week to extensively that 12-week period. Really, the issue is where's the money coming from in terms of the pocket for the medical benefits? If it's a work-related comp claim, then it's going to be coming from your workers' compensation policy. If it's not deemed work-related, then it's going to be coming from your employee benefits policy for the med benefits. So I hope that kind of cleared it up. There is a bit of an overlap. It would be more beneficial to take that upfront payment, but in the grand scheme of things, if you took that upfront payment and it was deemed compensable in the long run, you'd receive an offset for that and be entitled to ongoing benefits. So the quicker payout, yes. The long-term payout, if you do have a workers' comp claim, it would be quote unquote more lucrative, so to speak.
John, you got any comments? You good, John?
I was just going to add that another distinction which may make a difference is that the medical coverage, benefit coverage provided under workers' comp is only for the ailment that the individual is treating for, whereas the coverage required under the emergency FMLA is whatever coverage the individual had. So family coverage, for example. Whereas if I'm on a comp claim, I'm just getting treatment for my injury or my illness, not the family's not included in that. So.
Oh, looks like we got one last question here from Penny Orr here. Does it matter if we as an employer, excuse me, does it matter if we as an employer ask someone to quarantine, or does the employee need an order from a medical professional for the COVID leave?
That question is not answered by the Emergency Paid Sick Leave Act. I have been advising clients who have asked me that to pay them, because it exhausts some of the 80 hours that are up there. And because if you're not paying them, what you're doing is you're laying them off. But again, the statutory requirement is that the employee is subject to essentially a legal quarantine imposed by a federal, state, or local government, or a healthcare provider, or is actually experiencing sickness or symptoms, I should say, or caring for an individual. So if I'm just an individual employee and my employer is telling me to stay home, I don't meet any of those criteria. Technically, I'm not entitled, but under the circumstance, I think you can pay the benefit and reduce the entitlement going forward. Or, I mean, you're not legally obligated to do it, but if you do more than the law requires, you'll never get into trouble. So.
Ed, any comments? Or
No, I think that covered it.
okay. Well, I thought today was awesome. Really good questions and excellent responses. Do you guys have any words of wisdom to leave us on? Any parting words? Comments?
All I'll say is I would anticipate that the statutes that we've talked about will be extended into the new year. And if I were to betting man, I would say they will be extended through the end of next year at some point.
And I'll just say that, with anything in terms of liability, a lot of times the question is, how can I avoid litigation or liability? The short answer to that is you can never avoid somebody trying to bring a lawsuit against you. What I would advise in times like this, the more you hug yourself to the Osha guidelines, to the World Health Organization guidelines in terms of your business practices and how you respond to COVID, the better you're going to be from a liability and exposure standpoint in the future. So continue to stay updated on those guidelines, continue to follow them as closely as is possible within the framework of your business. And that's the best way to set yourself up for success when it comes to a liability exposure in the future.
Ditto.
Yeah, sounds good. Hopefully all your questions were answered. If not, like I said, I'll send their contact information around to everyone that registered, and you could follow up with them and improve your relationship with them. So again, on behalf of the KCA and everyone on the line here today, I just want to thank both John and Ed for your time and your knowledge. Thanks a ton, and I hope everyone enjoys Thanksgiving. Stay safe, enjoy your family, and we're in this together. So enjoy the holidays, everyone. Take care.
Happy Thanksgiving.
Thanks, guys.
Yeah. Let me see.